Hello students, I welcome you all to the EPG E-Pathshala for the module Women and Labour Law. This is paper Women and Law for subject Women Studies. Primarily, there are three objectives of this module. The first one is to apprise you with different laws regulating the terms of service and conditions of working women. The second is to develop a full understanding of rights of working women under these laws. And the third is to help you understand the need for improvement, if any, under these laws. One cannot deny the fact that socio and economic equality is the road to social justice. Women have always been at the receiving end of discrimination due to their special characteristics, physically as well as mentally. Now, if we talk about India, the social status of women puts them at a more disadvantageous position as far as the males are concerned. In the society, they have a lesser say and they are relatively backward. Moreover, their economic dependence makes them subordinate to their male counterparts. This difference of status becomes more evident when women leave the boundaries of their home and go out to earn a livelihood. Sometimes out of compulsion, sometimes out of choice. The situation of those who work not just for a living but out of passion is no different as they face another set of discrimination. Overall, it would not be much to say that women face typical problems at their workplace. That can be in the nature of disparity in pay, employment at odd hours, lack of facilities at workplace suiting the needs of a woman, denial of maternity benefits, sexual harassment, and so many others. As women constitute almost half of labor force in India and make a majority contribution to the economy, it becomes very important to help these women enjoy the equality that they deserve as a human being. The concept of human rights of labor rose to importance with the setting up of International Labour Organization in 1919. The ILO is the pioneer for safeguarding the interest of labor class all over the world. It has passed several conventions catering to the needs of the working class accordingly. As you all know, that International Labour Organization or the ILO was established as an organ of League of Nations in 1919. It had members from all over the world and they very much knew the then conditions of working class. The ILO introduced to the world the concept of social security and social justice and social insurance, and this was actually done by organizing the very first conference in 1920. This actually influenced the entire world and also the British colonies all over. India was amongst them to saw the change. Even though the first formal legislation on social welfare was actually passed in 1881 in England, the Factories Act. That time it was done to regulate the conditions of the workers because the Industrial Revolution had just happened earlier. It was only after the unrest of First World War that India got its first labour law in 1923, and that was as Workmen's Compensation Act, which is now known as Employees Compensation Act, and the Maternity Benefit Act. The Maternity Benefit Act was later passed in the independent India, in the free India in 1961. And this somehow pacified the workers in India at that time. However, these acts of 1923 can be said to be just the beginning. Eventually, with the introduction of Constitution of India in 1950, we saw a new beginning for labour laws in India. Apart from the fundamental rights like right to equality, right to form a trade union, and associations, and right against exploitation under Article 14, Article 19(1)(c) and Article 23 and 24 respectively, the Constitution majorly included rights for the laborers under Part 4th. It also enacted directive principles of state policy, which provides major reformatory and protective provisions for the labor class in India. The provisions under Directive Principles of State Policy, or DPSP as they are known generally, they are actually an obligation on the state, that is the country, that is the government, which it must fulfill to realize the ideals of the Constitution to its fullest. So in a way, they are the duties which must be performed by the state. The broader provisions of DPSP are Article 38, Social and Economic Justice, Article 39, Equal Pay for Equal Work and Equality in Work. It also protects health and strength of workers. It has some other important articles as well. Article 39A guarantees free legal aid. Article 42 guarantees just and human conditions of work and maternity relief to working women. Article 43 provides right to work, living wage and decent standard of life to all laborers. Article 43A secures participation in establishments and industries. Keeping in mind these principles of the Constitution, over 30 laws have been passed for safeguarding the basic rights of the labor. However, special consideration has been given to women to alleviate their condition at work and to ensure equality in all spheres of life. Specific provisions have been made for women thereunder. Those laws can be enlisted as the Factories Act 1948, the Employees State Insurance Act 1948, the Equal Remuneration Act of 1976, the Employees Compensation Act of 1923, the Minimum Wages Act of 1948, National Rural Employment Guarantee Act of 2005, the Contract Labour Regulation and Abolition Act of 1970, and the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act of 2013. Now I'm going to talk about a very important law, the Factories Act of 1948. As I told you, that the Factories Act for the first time was passed in 1881, which was applicable to the colonies of the British. That was actually done to protect children and to provide for a few measures for the health and safety of workers. However, this Act of 1948 was done to consolidate and amend the existing laws. The Factories Act is a part of labor welfare legislation where measures have been taken to protect health, safety, welfare, and to provide for working hours, leave and employment of young persons and women workers. It also provides for prohibition of employment of women during night hours. It also provides for prohibition of work in hazardous occupations of young persons and women. It also prohibits employment of women in pressing cotton where a cotton opener is at work. It fixes the daily hours of work at 9 hours. It also fixes the maximum permissible load that can be carried by a worker. It also provides for a provision for crèche for children of women workers. Under the Act, there are special provisions which have to be followed by the employer in those establishments where 30 or more women are working. The employer has been made responsible to maintain a separate room not only for women but room for the use of children under the age of 6 years of such women. That room has to be in a clean and sanitary condition, and the employer has to appoint a well-trained woman to take care of these children and infants while their mothers are at work. As we all can see, this is a social welfare provision which not only protects the very small children of these women workers, but also provides a safety to the women workers and their children. In fact, under Section 66 of this Act, there is a mandatory provision that no woman shall be required to work, and the woman actually will not be allowed to work in any factory except between the hours which can be from 6 a.m. in the morning to 7 p.m. in the evening. Other important provisions of the Act are provision for washing and bathing facilities, provision for separate toilets for women, provision for restrooms and canteens, provisions for mandatory benefits, Employees State Insurance Act 1948. This Act provides a scheme under which the employer and the employee must contribute a certain percentage of monthly wage to the insurance corporation that runs dispensaries and hospitals in working class localities. It facilitates both outpatient and inpatient care and free dispensing of medicines and covers hospitalization needs and costs. Under ESI, all insured women workers get sickness benefits, disablement benefit, medical benefit, and funeral expense along with insured men workers. In addition to these benefits, insured women workers also get maternity benefit in case of certain contingencies arising out of pregnancy, confinement, miscarriage, sickness arising out of pregnancy, premature birth of child, or miscarriage and death. The provisions of this Act apply to all factories, including factories belonging to the government other than seasonal factories. One of the most beneficial pieces of legislation guaranteeing social insurance is Employees State Insurance Act. The Equal Remuneration Act of 1976. There is a common belief that women are physically weak and should be paid less than their male counterparts for the same piece of work. However, to tackle this issue, the Equal Remuneration Convention of ILO was ratified by India in 1958, and pursuant to that act was enacted. This act provides no discrimination is permissible in recruitment and service conditions except where employment of women is prohibited or restricted by law. It also guarantees equal pay for equal work for women and men. In Air India versus Nargesh Mirza, the air hostess of Air India brought a case against their employees, contending that they were being discriminated against assistant flight pursuers who did more or less the same kind of work on flights, but had better service conditions and other facilities. The Supreme Court struck down the provision of rules which stipulated termination of service of an air hostess on her first pregnancy, as it was arbitrary and aberrant to the notions of a civilized nation. The Employees Compensation Act 1923. Under this Act, compensation is to be paid for accident arising out of and in the course of employment. Both the injuries as well as death are covered. The dependent under the Act can claim compensation in both cases, which is death or injury. Under the Act, an employer is liable to pay compensation in the following cases. 1. If personal injury is caused to a workman by accident arising out of and in the course of his employment. 2. If a workman employed in any employment contracts any disease specified in the Act as an occupational disease peculiar to that employment. Under the Act, the employer is not liable to pay compensation in the following cases. 1. If the injury does not result in the total or partial disablement of the workman for a period exceeding 3 days, and if the injury not resulting in death or permanent total disablement is caused by an accident. The workman having been at the time of the accident under the influence of drink or drugs, or where the workman is committing the willful disobedience of an order expressly given or to a rule expressly framed for the purpose of securing the safety of the workmen, or where the workman has willfully removed or disregarded any safety guard or any other device which has been provided for the purpose of securing his safety, then in such case also the employer is not bound to give any compensation. This law applies to both unorganized sectors and to those in the organized sectors who are not being covered by the Employees State Insurance Act of 1948. That is why it is seldom said that Employees Compensation Act and Employees State Insurance Act provide for alternative remedies to the workmen. Minimum Wages Act of 1948. Wages under this Act have been classified into three different categories. The first one is living wage, then minimum wage, and then fair wage. Living wage has been defined or rather talked about in Article 43 of the Constitution of India. It states that the state shall endeavour to secure by suitable legislation or economic organization or in any other way to all the workers a living wage, conditions of work ensuring a decent standard of life, and full enjoyment of pleasure and social and cultural opportunities. Therefore, we can say that living wages actually mean the provision for the bare necessities plus certain amenities which are considered necessary for the well-being of the workers in terms of their social status. As far as minimum wages are concerned, they may be defined as the lowest wage necessary to maintain a worker and his family at the minimum level of subsistence. This may include food, clothing, and shelter. When the government fixes minimum wage in a particular trade, the main objective is not to control or determine the wages in general, but to prevent the employment of workers at a wage below an amount which is in a way necessary to maintain the workers at the minimum level of subsistence. The last category of wages, that is fair wages, is something which is more than minimum wage but a little less than living wage. So we can say that fair wage is a mean between the living wage and the minimum wage. The major provision of the Act is pertaining to fixation by the central government of the minimum wages for employments which have been detailed in the schedule of the Act. The underlying purpose of this Act is to prevent exploitation of workers by their employers. Mahatma Gandhi National Rural Employment Guarantees Act of 2005. This law is a social security measure that aims to guarantee the right to work. The Act provides at least 100 days of guaranteed wage employment in every financial year to every household whose adult members volunteer to do unskilled manual work. The beauty of the Act is that under the Act, priority is given to women in allocation of work. Gender equality is one of the core elements of this poverty reduction plan, which stipulates that at least 1/3 of the labor force should be women, with equal wages for both men and women. As it is a social welfare act, various gender-related objectives such as provision of hygienic work environments, safe drinking water, and childcare facilities at the work site, distance of workplace not exceeding 2 miles from the home, healthcare, and nutrition have been emphasized under the Act. Women engaged in agricultural farming spend long hours under the hot sun and are invariably paid less than their male counterparts. Women's participation in the labor force with no wage discrimination and direct control of resources and assets can substantially enhance her health. child welfare, and socio-economic status. This employment policy, if implemented properly, can certainly bring momentous changes in the lives of women. The next act that I'm going to discuss is the Contract Labor Regulation and Abolition Act of 1970. This act actually applies to any establishment in which 20 or more workmen are employed on a contract basis on any day of the last 1 year, and also to all contractors who employ or have employed 20 or more workmen on any day of the preceding 12 months. Particularly Section 16 to Section 21 of the Act deal with welfare and health of contract labor, both of men as well as women. A contract laborer is defined in the Act as the one who is hired in connection with the work of the establishment by a principal employer through a contractor. While a contractor is the supplier of the contract labor for the organization, a principal employer is a person responsible for the control of the establishment under Section 2 of the Act. Every contract worker under the Act needs to be paid as per the Minimum Wages Act. As I've already told you, that under the Minimum Wages Act, the wages must be paid by the employer, the ones which have been fixed by the central government in certain employments, both to men as well as women. Under the Act, many provisions have been made pertaining to health and security of even contract workers. There are mandatory provisions for safe drinking water, canteen facilities, first aid facilities, and protection of women under the Act. It has also been provided under the Act that if the contractor fails to pay the wages or provide those mandatory facilities, the responsibility will actually fall on the principal employer. In this way, the Act checks the fallacies on behalf of the contractor by putting the responsibility on the principal employer, and thereby ensures that even the principal employer provides those basic facilities which have to be given to the workers under the Contract Labor Act. Lastly, I will talk about the legislation which has actually provided the protection to women at workplaces. Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act of 2013. This is the only act which is applicable to a workplace in terms of safety and security of a woman, because it specifically deals with those cases which can be called or which can be put under the category of sexual harassment. For the first time, the Act has provided a definition of sexual harassment. Prior to that, the definition was laid down, or rather the concept of sexual harassment was laid down by the Supreme Court of India in the very famous, or rather infamous, case of Vishakha versus State of Rajasthan, where a social worker was raped while she was working. For the first time, the Supreme Court construed the provisions of international law to be a part of law of the land, as there was no specific legislation. Under that particular case, the Supreme Court provided that the employers and local authorities will have to set up a grievance committee to investigate all the complaints which might fall under the category of sexual harassment. And any employer who fails to comply with that kind of a provision, that is setting up of the committee, will be punished with a fine of up to 50,000 rupees. Following the guidelines laid down by the Supreme Court in Vishakha case, the Act defines sexual harassment at workplace and creates a mechanism for redressal of complaints. It also provides safeguards against false or malicious charges. So, One cannot say that this is just a legislation which is providing that safety or cover to women. Not like that. It also provides that safety to people against false complaints. The Act also covers concept of quid pro quo harassment and hostile work environment, because these have been construed and rather defined under the Act as forms of sexual harassment, if at all these acts are occurring in connection with the actual act of sexual harassment or behavior of sexual harassment. The Act has also defined who is going to be an aggrieved woman. The definition of the aggrieved woman gets protection under the Act, because this definition is very wide to cover all women irrespective of the age or employment status, whether in the organized sector or in the unorganized sector, whether in the private or public sectors, and it also covers clients, customers, and domestic workers as well. Under the Act, the employer is required to constitute an internal complaints committee at each office or branch with 10 or more employees. So we can see that the Act has aimed to check sexual harassment at workplace in those organizations where less number of women are working as well. The district officer is required to constitute a local complaints committee at each district, and if required, even at the block level of a particular state. The complaints committee is said to have the powers of civil courts for gathering evidences, calling witnesses on oath, and taking care of procedural matter. The complaints committee under the Act are required to provide for conciliation before initiation of the inquiry, if requested by the complainant. I think all of us know that wherever a woman is involved and issues of sexual harassment are involved, there is a likelihood that woman is very, very apprehensive of the kind of environment that she might have to face after that complaint or after she leaves that particular workplace. So not necessarily there always has to be a proper prosecution of the offender. The woman can request conciliation and they may talk about whatever has happened and they may come at an amicable settlement of the matter. The inquiry process under the Act has to be confidential, and the Act lays down that a penalty of 5,000 will be levied on the person who has breached the confidentiality. This has been done to protect the privacy and identity of the woman. In case there are repeated violations, they may lead to higher penalties and cancellation of license or registration to conduct business. It is also a welcome step that the Act requires employers to conduct education and sensitization programs and to develop those policies which can cater to that understanding against sexual harassment, among other obligations. In fact, the Act also provides that the government can order an officer to inspect a workplace and records which are related to matters of sexual harassment in any organization. While the workplace in Vishakha guidelines is confined to the traditional office setup, where there is a clear employer-employee relationship, the Act has gone much further, because in today's world there are many complex relationships which cannot be classified as employer-employee in black and white. And therefore, this workplace has been defined to include organizations, departments, offices, branch units, etc. in the public and private sector, organized and unorganized sector, hospitals, nursing homes, educational institutions, sport institutes, stadiums, sports complex, and any place which has been visited by the employee during the course of employment, including transportation. Even non-traditional workplaces which involve telecommunicating, they have been covered under this law. In the end, my friends, I would like to tell you that though adequacy of laws and reforms is always a relative factor, still one cannot say, and it cannot be denied, that the labour laws in India are nonetheless pro-women. However, the problem is with the implementation, because implementation of the same is the call of the time to ensure social justice in true sense to such women. Thank you.